Good morning, everybody. Welcome to the February edition of Outline, DLA Piper's Planning Law Update. As previously, what we try to do with these sessions is to really focus on the practical consequences of the latest developments in planning law, trying not to get too bogged down in the law. But as a group of lawyers talking about planning law, let's see how we get on with that. We'll keep very much to time, so we'll try to speak and discuss for about 45 minutes, leaving us 15 minutes at the end of the session for any questions from you. If you do have questions, please do put those into the Q&A function on your screen, and we will get through as many of them as we can at the end of the session. Equally, as ever, if you've got questions, do feel free to reach out to us after the session. And we'll do our best to help. I'm joined today by two of my colleagues. Firstly, by Amy Truman, who is a legal director in the planning team, and also by Michael Grieg, another of my legal directors. Michael brings a slightly different flavour to today's proceedings in that Michael is based in Scotland, and so he's going to give us a bit of a Scottish perspective today on some of the things that we are talking about. So without further ado, let's begin. If I can have the first slide, please. And just a quick highlight of legislative changes, mercifully few in the last month. The only significant change to report is yet more amendments to the CIL Regulations. The first, but I'm prepared to bet not the last, of 2021, because ever since those CIL regs were passed in 2010, we have seen them amended at least once a year, and quite often two or more goes each year. So I think it must be in the running for the most amended set of regulations of all times. The changes that have come into force, though, with the latest amendments are not massively earth-shattering. The fundamental change is effectively it's giving the Mayor of London another 10 years to keep using CIL for the purposes of funding Crossrail, whereas that was due to expire in 2033. The Mayor now has until 2043 to keep using CIL to fund Crossrail. With any luck, it will be open at some point between now and 2043 when we stop paying for it via CIL, at least. That's the only change in the regulations, so as I say, a fairly minor one, which means we can move on to the next slide, please. And the first topic of the day, and we're going to spend a little bit of time today looking at the much discussed tilted balance set out in paragraph 11D of the National Planning Policy Framework. And I think the reason we're going to spend a bit of time on this is that we've seen a remarkable number of judgments from the Court of Appeal in the last 3 months, and three in particular that I want to just flag up to you all today, all of which are looking at different aspects of paragraph 11D of the framework. Now I say the tilted balance in NPPF 11D, but of course, as you'll see from the screen where I've set out 11D, the tilted balance is actually only the last part of 11D. It's 11D2. The rest of 11D are the triggers and the hurdles that you need to overcome as an applicant if you want to try and take advantage of the tilted balance. You've got to get to D2 in order to use the tilted balance. Each of the cases has considered a different part of 11D, and so I think collectively they're pretty much essential reading for anyone who's trying to properly apply the paragraph in planning statements, proofs of evidence, or decision making. So collectively they are worth a read, I would suggest. Before I get into the cases, let's just start with a quick refresher. As I suspect we all know, paragraph 11 of the framework sets out the all-important presumption in favour of sustainable development that is at the heart of government's policy and the framework for the planning system in England. Of course, it does only apply to England. We'll come on to Scotland a little bit later. The first part of paragraph 11, that's subparagraphs A and B, they deal with how to apply the presumption to local plan making. The more interesting bit by which I mean the bit that the courts tend to end up having to scrutinise much more closely, are the second, or the second chunk, the last two subparagraphs C and D, and they deal with the application of the presumption in the context of the determination of planning applications. As I'm sure we all know, paragraph C tells us that when an application accords with an up-to-date development plan, the presumption means that the application should be approved without delay. And I suppose so far so uncontroversial in that sense. The controversy and the bit where we as lawyers tend to find ourselves most heavily involved, and certainly where the courts find themselves most heavily involved, is in paragraph D, which, as I say, is set out on the screen. And the first of the cases I want to talk about is the Paul Newman's Homes case. And in that case, the court was considering, and particularly the phrases that I've coloured on the screen for you. Firstly, the trigger of no relevant development plan policies and what that means, and then secondly, the other trigger in that first part of paragraph D, i.e. the trigger that the policies which are most important for determining the applications are out of date. And dealing with the first of those, i.e. the meaning of no relevant development plan policies, what the court held was that a policy is relevant if it has a real role to play in the determination of the application. But the court said that didn't mean that the policies had to be enough on their own to enable the application to be determined. So in order to be a relevant policy, it doesn't have to be determinative of the outcome. It doesn't have to enable you to assess the outcome of an application in its entirety. It simply has to have a real role to play in that determination process. And alongside that clarification of what a relevant policy is, the court also focused on the word no. In that great legal way, they actually needed to think about what no meant. And what the court said was it really means what we all know that it means to start with, which is that as long as there's at least one relevant policy, i.e. one policy that has a real role to play in the determination of the application, then the first trigger for applying the tilted balance is not engaged. So as an applicant, you need to show that there are literally no relevant policies before you can rely on that first trigger to move down through paragraph 11D. Having done that, the court then went on to consider the second trigger, i.e. the question of whether the policies which are most important for determining the applications are out of date. And in particular, what the court was looking at here was the question of how you establish what the most important policies are in order to apply that second possible trigger for the tilted balance. And here, what the court held was that a decision maker has to carry out an evaluation of the relevant policies, so those policies that the decision maker has identified as being relevant for the first trigger. Once you've done that, you have to evaluate those relevant policies and conclude on which of those policies are the most important in the context of the particular case that's being considered, the particular application that's being considered. So there's no hard and fast rule. There's no way of saying this is an important policy and that one isn't. It will be a matter of judgment in the context of a particular application as to which are the most important policies. But critically, those most important policies have derived from the relevant policies that will already have been identified in that first trigger in 11D. So, but putting those two things together, what the court said was they upheld the inspector's conclusion in the particular appeal. And in that case, what the inspector had concluded was that there was just one relevant policy. And so the court said, well, that by definition, if there's just one relevant policy, then that policy must be the most important policy for the second trigger of 11D. And therefore, the court upheld the inspector's conclusion that as the particular policy in question was not out of date, neither of the triggers were met, and the tilted balance in D2 couldn't be engaged. And I think that So far, so good. There's clearly a logic to that, but it does produce some potentially quite surprising results. And I think the case itself, the facts of the case are worth looking at as an example of that. So the case was concerned with an application for housing development in the countryside in the district of Aylesbury Vale, just outside of Milton Keynes. Aylesbury Vale, as many of you will know, have not found it easy to keep their local plan up to date. And in fact, they're still working from the plan that was adopted back in 2004. Critically in the case, the plan having been adopted in 2004, it predates the Planning and Compulsory Purchase Act of 2004. And so the plan has been through the saving exercise that is set out in the 2004 Act. And crucially, all of the plan's policies dealing with the approach to development in the countryside had not been saved. So they had expired, were not part of the development plan at the point that this application was determined. But nonetheless, in refusing permission, the council, and then in refusing the appeal, the inspector had both relied on a saved design policy. And that design policy was contained in the chapter of the plan that was headed Conservation of the Built Environment. And because it was focused on design, only some of the criteria set out in that policy were relevant at outline stage. But nonetheless, the court concluded that both the inspector and Sir Duncan Ouseley, when he had upheld the inspector's decision in the High Court, were right to conclude that the policy was relevant insofar as it had a real role to play in the determination of the application, and also that as it was the only relevant policy in the current adopted development plan, it therefore was the most important. So the conclusion of the inspector, which was upheld by the court, was as that policy was not out of date, and given that the council could demonstrate a 5-year supply of housing land, the tilted balance was not and could not be engaged. So I think for me, this is an important case that makes it in many ways much harder for the tilted balance to apply unless policies are out of date, or in the case of housing applications, the planning authority can't demonstrate a 5-year land supply. Otherwise, it only needs one policy of the plan to be up to date and relevant to potentially lead to an inability to trigger either of the two triggers set out at the beginning of 11D. Moving on to the next slide and the next case on 11D, this was just a couple of weeks later. The Court of Appeal handed down judgment in the Monkhill case. And in that case, the question before the court concerned whether D1, so the words that are highlighted on the screen now, applied, and in which case, again, if D1 does apply, one does not get to apply the tilted balance in D2. You do not get to pass go and don't get to collect your £200. Now, as avid readers of the framework will know, D1 has a footnote 6, which sets out which policies of the framework D1 is referring to. And critically, in the Monkhill case, footnote 6 identifies the policies relating to areas of outstanding natural beauty, AONB, as being policies to which D1 applies and refers. And the case was particularly concerned with the AONB policy that's set out at paragraph 172 of the framework. And that policy effectively has two parts within it. The first part of the policy says that great weight should be given to conserving and enhancing landscape and scenic beauty in AONB areas and indeed in some other designated areas. Having said that, it then goes on and says that planning permission should be refused for major development in the AONB other than in exceptional circumstances. And it then sets out criteria against which those exceptional circumstances can be established. Now, in the case, the inspector had come to the conclusion that the development was not major development. And so the second part of that policy in 172 didn't apply. The criteria-based, exception-based approach, and crucially, the requirement that, or the mandating of planning permission needing to be refused in pursuant to the policy. So that didn't apply, but nonetheless, the inspector concluded that the first part of the policy was relevant, i.e. the general requirement that great weight should be given to protecting landscape and scenic beauty within AONB. Having held that that was relevant to the determination, he then formed the view that there was a significant adverse effect on the character and appearance of the AONB resulting from the application. And therefore, he concluded on appeal that NPPF 11D1 did apply, and therefore he declined to allow the tilted balance to be engaged, even though he found that the council could not demonstrate a 5-year land supply. So the court agreed with that approach, as had Mr. Justice Holgate in the High Court, and what the Court of Appeal held was that there is no requirement for a policy to have to direct refusal or to apply a criteria-based approach in order to fall within footnote 6 and so trigger paragraph D1 and thus prevent the tilted balance from applying. What the court did say, though, was that it's not enough to trigger D1 for a footnote 6 policy to be engaged in a particular application. What the court indicated was that the policy, if it is engaged, has to be applied, and the result of the application of that policy must be that it provides a clear reason for refusal, was the words used by the court. So to the court's mind, it was enough to engage D1 and to disapply the tilted balance that the inspector had considered the requirement to place great weight on the need to conserve and enhance landscape and scenic beauty of the AONB, and then to have formed the view that the significant adverse impact he identified was such as to lead him to conclude that the policy resulted in a clear reason to refuse the appeal that was before him. So I think for me, the important point coming out of this case is that it's difficult for applicants trying to rely on the tilted balance if they're carrying out development or proposing to carry out development in areas where footnote 6 policies apply. So that's Greenbelt, it's AONB, it's where heritage policies apply to designated heritage assets and various other situations. And I think that for me, it's probably with heritage policies that there's most general relevance comes out of this case, because if you're looking at those heritage policies in the context of designated heritage assets, some of the NPPF heritage policies are quite directive of requiring refusal, and they're quite clear on how that should be approached. Others are simply requiring a balancing exercise, particularly I'm thinking of if there's a finding of less than substantial harm to a designated heritage asset, the balancing exercise that's required there. If the application of that balancing exercise suggests that the application ought to be refused, that is enough to trigger through footnote 6, paragraph D1, and so to prevent the tilted balance of D2 from being engaged. Finally, on the next slide is yet another Gladman case, of which there have been many over the years. But this is the first of the 3 cases I wanted to talk about this morning under NPPF 11, which actually got to the point of engaging the tilted balance. So this case is considering actually how one applies the tilted balance in D2 rather than whether you get to it in the first place. And I think for me, there are 2 interesting points that come out of the decision. First, Gladman had sought to argue that the inspector had been wrong to take account of conflict with development plan policies when carrying out the tilted balance. And the logic for that was the reference in D2 to the fact that the assessment has to be carried out against the policies of the framework taken as a whole. The court didn't accept Gladman's position. The court was of the view that there was nothing in D2 that meant that development plan policy compliance or otherwise should be ignored when carrying out the tilted balance. On the contrary, the courts considered that it was entirely appropriate and proper that a consideration of the adverse impacts and the benefits of a proposal should include consideration of conflict with or conformity with development plan policy. So I've seen a number of times on appeal, I've seen it argued that you should exclude the development plan from a tilted balance exercise. The court is very clear that is not the case. The development plan should have a role to play in the consideration of the tilted balance. The second interesting point for me that comes out of the Gladman case concerns the relationship between the tilted balance and the application of the statutory test in section 38.6 of the 2004 Act, which, as I'm sure everybody knows, requires applications to be determined in accordance with the development plan unless material considerations indicate otherwise. And the framework, of course, being one of those material considerations. Now, what the inspector had done in this particular case was he'd considered both the tilted balance and section 38.6 together and formed an overall conclusion on both at the same time. And Gladman criticised this approach, and Gladman argued that the proper approach would have been for the inspector to first form a conclusion on the outcome of the tilted balance, and then to feed that conclusion in to a separate application of section 38.6. And the court, the court's view was that ultimately that there's no right or wrong answer to that point, and it's a matter for a particular decision maker to decide whether they want to adopt the sequential approach that Gladman was arguing for, or whether they want to take both questions together and undertake a single exercise. What the court did say, though, was that if a decision maker is undertaking both exercises at once, then they do need to remember that the tilted balance is only a policy presumption, and they need to keep in mind the statutory primacy of the development plan and the section 38.6. So whilst you can do both together, if you do, you need to take care to make sure that you're not treating them the same. There is a difference in approach, given that the section 38.6 test is a legal test, whereas the tilted balance is simply a policy test that gets fed in as a material consideration to the application of that legal test. So an interesting point there in terms of the approach to take. Whilst I'm sure those involved in appeals will continue to invite inspectors to take a sequential approach or otherwise, depending on the case that's being put, there is no right or wrong answer to that. And ultimately, it's a matter for the decision maker to decide how to run those two tests and whether to take a sequential approach or not. So that's what I was sort of going to say on those three cases. As I say, given that they quite neatly run through all of the different stages of 11D, they are well worth a read if you are grappling with how to apply 11D, and critically, if you are trying to get to an application of the tilted balance in D2, then there's some important reading there for all of you. But I think that's the test in England. Now, if we can go on to the next slide, I think, Michael, there's a slightly different approach starting to develop in Scotland, I think, after a while of a similarity between the two government policy statements. It's changed a little bit, hasn't it?
Yeah, I suppose this kind of illustrates how things can change in quite a short period of time, because if I was doing this talk back in June last year, I think what I'd be saying would be quite different. So it'd be just worth just giving a bit of history as what's happened in Scotland, for those of you not necessarily familiar with it. Our equivalent of the well, we've got the Scottish planning policy, which sets out the policy of Scottish ministers in relation to the planning system. It sits alongside the national planning framework. National planning framework is a statutory document, whereas the SPP isn't. But having said that, the SPP is actually the document that you tend to look at more on a day-to-day basis, because it contains the meat of policy, whereas the NPF is much more sort of mum and apple pie type planning policy, as far as I'm concerned. We had a major review of the SPP back in 2014, and when it was initially put out to consultation, the SPP didn't contain a presumption in favour of sustainable development in the way that the the NPPF did at that time. We then had quite a lot of representations, particularly by the house building industry, to suggest that that should be introduced. In particular, it was thought that Scotland was potentially a competitive disadvantage if it didn't have such a policy statement within it. It might make the environment less attractive for development compared to south of the border. So the Scottish Government were convinced by that and introduced a presumption in favour of sustainable development in the finalised SPP. Now, the wording is slightly different to England, and the basic presumption in favour of sustainable development is the same. But what we don't have, or what we didn't have until there's been various changes, which I'll come on to, which were introduced in December 2020. What we didn't have was the detail that exists in the NPF. So all that the detail that Trevor's just been talking about in terms of paragraph 11 of the NPPF and the various tests that apply. We didn't really have that in Scotland. There was a much more of a generic approach. So essentially, what the relevant paragraph, which is paragraph 33, says is where relevant policies in a development plan are out of date, or the plan doesn't contain policies that are relevant to the proposal that you're looking at, then the presumption in favour of development that contributes to sustainable development will be a significant material consideration. So that's effectively the test. It's a much more generic test than I think that was in the NPPF. And allied to that was a separate paragraph 125, which dealt with shortfalls in the housing land supply. So if you had a shortfall in the 5-year effective housing land supply, then what the SPP said is that development plan policies for the supply of housing land will not be considered up to date, and the paragraph 35 would apply. So effectively, what it's doing, or what it was doing, was saying that if you've got a shortfall in the housing land supply, housing land policies would be considered out of date, and in those circumstances, the presumption in favour of sustainable development would be a significant material consideration. So that's how it operated. Now, the Scottish Government, when they introduced this policy, were quite clear that as far as they were concerned, the Scottish approach on the presumption was different to that in England. But what they never really did, though, was articulate what that meant. In what way was the presumption different? Now, obviously, at the time this was introduced, the NPPF itself was a slightly different state, and we actually held a seminar in our Edinburgh office just as this was being introduced, and we had the chief reporter she's in charge of the Director for Planning and Environmental Appeals, the Scottish equivalent of PINS, and we asked her about this, and because it seemed to us that effectively the wording of the policy in the NPP versus the policy in the NPPF at the time were essentially the same. There was a slight difference in how it was expressed, but essentially it was the same thing. But she assured us that it didn't introduce any fundamental change in the approach, and as far as the Scottish ministers were concerned, it was just a slight change of emphasis, but it didn't change anything in terms of the basic approach in planning law. And so that's the approach that they articulated at that point. We then had various debates at appeal, accumulating last year. Again, Gladman turned up, as they always do, in the Gladman case in about June 2020. And this looked at the history of cases in England in a Scottish context, and whether the tilted balance, which has been developed by the courts in England, applied in Scotland. And what's interesting is the Inner House looked at paragraph 33 of the SPP, looked at the cases, and what they said was that where you're looking at a situation where there's a shortfall in housing land supply, then and the presumption in favour of sustainable development is engaged as a significant material consideration, What's required is a question of whether the adverse impacts of the proposed development significantly and demonstrably outweigh the presumption. So effectively what they're doing is really introducing the sorts of approach that you see within paragraph 11 of the NPPF, and the court were confirming that in Scotland a tilted balance did apply much along the same lines as in England. So in June 2020, if I'd been speaking then, I think what I probably would have said at that point in time is that in Scotland, from a development perspective, the position which had been developed by the courts in Scotland possibly made it easier from a developer's perspective, at least, to argue a case for housing development where there's a shortfall in the 5-year housing land supply, because the tilted balance applied, but applied in a much less, if you like, rigorous way, because you didn't have to go through that series of tests as per the NPPF. It was a much more generic approach, and it was more a question of balance, but it was a balance which was perhaps easier to apply. So that was the position then. Now, the difficulty then is that the Scottish Government didn't like the outcome of the Gladman case, and no sooner had the Inner House released their judgment than the Scottish Government put out a technical consultation on proposed policy amendments to the SPP. Now, this all takes place as well in the context of overall a period of overall reform in the planning system north of the border, because we had the Planning Scotland Act 2019 passed. That is going to make a number of very fundamental changes to the planning system. So it will one of the things it will do, for example, is it will combine the National Planning Framework and the Scottish Planning Policy to one policy document, which then becomes part of the development plan. So it elevates the status of national policy. And also, national policy will then play a role in setting housing targets. Now, I have no doubt that when they're looking at the potential outcomes of the Gladman case, Scottish ministers must have had it in mind that they were the ones in due course that would be setting housing targets. And whereas at the moment, it's the local politicians that have got to deal with the difficulties of doing that, it's going to be elevated up to them. So that probably fed into their thinking. There's also, there was also a lot of pressure from local planning authorities dealing with shortfalls in housing land supply to change the approach from Gladman. They were very concerned that this basically meant that they would lose control of the planning system. And certainly from my perspective, I think the relationship between local and national planning authority in Scotland is a much cozier relationship, if I can put it that way, than the equivalent relationship in England. It's much closer, and local planning authorities have got more sway over Scottish ministers. So that plays a part as well. So we then got the technical consultation, and at that, when it was released, Scottish ministers completely proposed removing the presumption in favour of sustainable development, really putting things very much back on a pre-2014 basis. What they also were looking at were other ways of changing the approach to housing land, in particular shortfalls in affecting housing land supply. So they were looking to reframe the tests of when housing sites are effective, particularly by removing or reframing the extent to which you have to take into account deliverability of housing sites. So that would have made it much easier for planning authorities to argue that a site should be counted, and hence easier to show that they had an adequate supply. And they also plan to propose changing the calculation of the way that housing land requirements are calculated. There's been a big long debate between planning authorities and developers about what the appropriate mechanism was. The debate really being about, did you take into account the cumulative impact of shortfalls from previous years and add them into the mix so that the housing land requirement increased as you went along, or did you just take an average of what the development plan says is required for each year and base it on that model? So that was the consultation that place. House building industry was really very concerned about the nature of these proposals, made very strong representations. And then in December, Scottish ministers issued their response to the consultation and the proposed finalised amendments. So what they've done is they have not removed the presumption in favour of sustainable development, but they have reframed it. So what's changed now is that the presumption is no longer a significant material consideration in the determination of planning applications. It's been reduced in terms of materiality to just a material consideration. And also the specific linkage for where there's a shortfall in the housing land supply triggering the application of the presumption in favour of sustainable development, that's been removed again, so that in a similar way, if there's a shortfall in the housing land supply, then that's just a material consideration for determination. So again, we're now in a position, certainly as I read it, as it currently stands, these are just purely material considerations in the determination of the application. There's no higher level of weight to be attached. So I think the outcome of all of that effectively is that the tilted balance really no longer applies in Scotland, and that where we are, I think, is really back to the position that we were in prior to 2014, where if there's a shortfall in the housing land supply, then you would just be arguing that that's a factor to be given a high degree of weight to back an application for housing development to make up the shortfall, but you don't have the benefit of a tilted balance in terms of national policy to back that up. So we've got that. Scottish ministers have not at the moment, in some ways it's not as bad as it could have been, if you like, from a development perspective, because the presumption hasn't completely gone. It's just been trimmed and declawed, I suppose you could call it. They haven't implemented the changes to the definition of effectiveness, albeit that's something that may be coming with the new NPF when that's implemented. But what they have done is they've also introduced a new planning advice note to change the calculation of the housing land requirement, which follows the compound model. This was the compound model as proposed by the planning authorities. And effectively what that does mean is that effectively the level of the housing land requirement is going to be smaller than it would have been using the residual method which the house building industry had proposed. So that also has a practical difference. So that's where we are. As I say, a lot has happened in quite a short period of time, and it just illustrates how quickly things can change.
And the dangers of being too much like England, you're up there, clearly is not the way that the Scottish government wants to see their planning policy evolve, by the sounds of it.
Apparently not. Who knew?
Who knew? Shock horror. Thank you, Michael. Okay, Amy, move us away from the tilted balance. If we can have the next slide, please. And Amy, you can talk to us still about the NPPF, but about something slightly different.
Hi, yeah, I was hoping to completely avoid the term tilted balance, but actually this case does mention the words tilted balance, not in the same context that Trevor and Michael have been talking about, but even so, as I got to that point, I was like, oh no, coming back to that again. Anyway, I'm going to talk about a recent case of the Crown on the application of Sue Wyeth Price and Guildford Borough Council. This case relates to a heritage point. There are 3 grounds of challenge, but it's only the heritage point that's successful, and it's only that that's really particularly interesting. So related to an application by Bewley Homes, the construction of 73 dwellings, they were granted planning permission which was then challenged by a third party. So the development site was adjacent to a complex of historic buildings. There were 2 that were grade 2 listed buildings and 1 grade 2 star. Historic England had had a look at the proposed development and decided that they thought it would cause harm to the setting of the heritage assets, but that this harm was less than substantial harm. So the case is about the exercise really that the planning officer undertook when he was applying statutory duty, and then how the NPPF tests fit with that and how he applied those tests that come up in the NPPF. So I just put the an abbreviated version of the statutory duty on the slide. It comes up in section 66 of the Planning Listed Buildings and Conservation Areas Act. So that duty comes up when considering whether to grant planning permission for development which affects a listed building or its setting. The local planning authority or the Secretary of State needs to have special regard to the desirability of preserving the building or its setting or any features of special architectural or historic interest which it possesses. So because of Historic England's advice, we know that the proposed development would cause harm, and therefore the statutory duty is engaged. It doesn't matter that the harm is less than substantial to engage that statutory duty. We also know, because of a previous case, Jones and Mordew, that once you're trying to discharge your duty under section 66, you can or should follow the provisions in the NPPF. And the decision in the Bewley Holmes case that I'm talking about, also points out that the NPPF provisions, they're not statutory, but they are a material consideration, and therefore they're expected to be dealt with. So looking at how they were dealt with, the planning officer did realise that the NPPF is relevant and did look at chapter 16. But in his first committee report, he only referred to the first part of chapter 16, or well, the relevant policies contained in chapter 16. So those were paragraphs 189 to 192, which those are the policies which relate to how to assess a heritage asset and its significance and the harm to that significance, but not how to then assess the impacts. He then came back to his report at a later date and revised it after there were some amendments to the development. And he did at this point include paragraph 196, which is one of the paragraphs of the NPPF, which looks at how to assess the impact. And 196 is talking about where a proposal will lead to less than substantial harm, which this proposal clearly does. But what he hadn't done was look at paragraphs 193 to 194, which he needed to go through before he got to the test at 196. So paragraph 193 requires great weight should be given to the assets conservation, irrespective of the amount of potential harm that could be caused to the asset. So it doesn't matter whether the potential harm is significant or less than significant. If there is a harm, great weight has got to be provided to that harm. And then under section 194, there needs to be any clear and convincing justification for the harm or loss of significance to the heritage assets. So it was those two paragraphs that he'd failed to consider and failed to draw the committee's attention to. So in that case, he hadn't properly undertaken his assessment in accordance with the NPPF, and he'd skipped some really important paragraphs. And those important paragraphs, if you go back to section 66, they meant that section 66 hadn't been followed because he'd failed to have that special regard to the preservation of the building by skipping by skipping those paragraphs and going straight to 196 and merely then weighing any public benefits against the less than substantial harm, failed to look at the importance of the great weight to be given to the assets conservation. So that great weight to be given to the assets conservation does tip the balance to put greater weight on the harm, which he'd failed to do. So even where the harm is slight, it still needs great weight to be afforded to it to comply with what is required by the NPPF and therefore deal with the duty that comes up in section 66. So really this case underlines the importance of just following the NPPF just step by step in each paragraph, and I think really showing your workings as well once you've done that.
It very much does to me, Amy. It picks up on that Mordew point of if you properly apply the NPPF tests, then you will have met the statutory duty.
Yeah.
And what this is saying is, yes, that's right, but you've got to properly apply the NPPF tests. If you get that wrong, if you miss steps, then you're not necessarily applying the NPPF properly, but you're also not complying with the statutory duty to have that special regard.
Yeah, and there was some weight in their case as well put on the importance of, the planning committee got to understand what weight and how they were undertaking their exercise and applying that tilted balance when they were going through that. So it's not merely a matter of maybe the planning officer looking at it, but he's got to report it so that the committee is going to understand.
Interesting case. Thank you, Amy. There's one more case I wanted to flag up on the next slide, please, which I'm conscious of time, but unfortunately I can do this one really briefly. It is not a case I recommend anybody reads because it's 51 pages long, and a large chunk of that I think is pretty uninteresting. But the Zins case, I think there is an interesting point that comes out of it. At the heart of the case was a condition that had been imposed on a planning permission in order to secure affordable housing. As you will know, traditionally affordable housing is secured by Section 106 planning obligation rather than by condition, but you do see conditions used on occasions, particularly in the context of appeals, if you are struggling to get agreement on affordable housing terms for a planning obligation with the local planning authority. And I think what the interesting point that comes out of this case is there was a challenge to whether a condition could be used to secure affordable housing. The condition was fairly standard in its structure in that it required the submission of a scheme for the delivery of affordable housing prior to commencement, and it set out in quite some detail what that scheme needed to cover in terms of location, mix, tenure, and so forth. Also, it required that a mechanism was in place to secure the transfer of affordable housing to a registered provider, and also required an alternative in the event that a registered provider couldn't be found to take the affordable units, so that there was a backup mechanism for delivery in that situation. And the conclusion of the court was that there was absolutely no reason why you couldn't deliver affordable housing in this way, and the judge in the High Court upheld the principle of allowing affordable housing to be secured by condition. I think it rests for me on the fact that the condition was suitably detailed and covered the points that would need to be caught by a scheme that was there for subsequent approval. But an interesting one for anyone who is using or wanting to use conditions to secure affordable housing. That the Zins case provides us with a clear steer that it can be done as long as the condition is drafted appropriately, so that the local authority has the necessary control over delivery moving forward. As I say, not a case I recommend anybody particularly reads because there's a lot in it that I don't think is necessary, but that it's good authority for that proposition of using affordable housing, or using conditions rather, to secure affordable housing. Great. So if we quickly, we've still got just 10 minutes left to get some questions in. We have had some questions through. If you've got any others, please do stick them in the Q&A and we'll get through as many as we can. Michael, firstly, one that's that's come through for you, and I suppose this picks up on your original point that that the reason that the tilted balance was brought in was a perception of a competitive disadvantage in Scotland if it wasn't brought in. So the question is, moving away from it, does that leave Scotland in a competitive disadvantage in terms of attracting that investment into development?
Well, it might do. I mean, I've been thinking about this because I suppose in practical terms, you were always able, even before you had the presumption in place, you were always obviously able to argue a case on the basis of a shortfall in the housing land supply. And what I've seen in terms of appeals in Scotland in any event is that even when the presumption's engaged, effectively, if they don't like the site for whatever reason, then there's a way is found of saying why the site's not sustainable. So the extent to which the presumption has really changed things in Scotland, I think is possibly a moot point. It's an interesting thing actually that and that's looked at in the Scottish Minister's consultation paper in the first place, where it tries to analyse the appeals and the extent to which the presumptions actually had any real change. So I do think there's a question mark there as to what extent has it really made a big change in Scotland? It certainly removes an additional argument in the armoury, though. So to that extent, there's a potential disadvantage in a development context in Scotland v England. To be honest, what would concern me more, I think, rather than the change to that, I'm more concerned about the changes to the definition of the housing land requirement, because that means that it's much more difficult now, I think, to establish there's a shortfall in the housing land supply in the first place. So you don't get to stage one. I think that's the difficulty. It's more difficult to actually would have been more difficult to get to the stage where whether it's a presumption in favour of sustainable development, or whether it's just a straightforward argument as a material consideration, given that it's not engaged because you won't have a shortfall. So I think that's the bit that worries me more in terms of the competitive disadvantage, that it's going to be more difficult to demonstrate a shortfall in Scotland than it was prior to December last year, because they've changed the definition.
Which for different reasons, but potentially we have the same issue down here in England with the changes to the standard method for calculating that housing need figure, and the sort of the move away from some of those areas where affordability has been particularly acute, and where they've therefore been struggling to meet the numbers that the previous standard method applied. That seems to me it's a similar problem we're wrestling with here as to whether those changes actually start to prevent that tilted balance kicking in England.
Yeah, well, I think the thing is also, what's interesting is that when it came to appeals, I think the difficulty the Scottish ministers also had was that their own reporters were backing up the residual method that was being proposed by the development industry. So that caused a lot of issues as well. So effectively, they've decided for policy reasons they don't like that approach, and they want to go a different way.
Amy, question coming for you in terms of the heritage case. The question is was the issue fundamentally one of failing to include the workings in the committee report?
No, it wasn't. The judge had a good look to see whether she thought that the exercise had been carried out properly but not reported, and decided that that wasn't the case. But she was more concerned that, as well, whether the committee had been properly advised so that they could undertake their balancing exercise correctly, which they hadn't been. And clearly she could tell that these two paragraphs, which are really important to make sure that the statutory duty had been complied with, just hadn't been looked at, and definitely the planning committee hadn't been advised to look at it, and particularly because there were new people in the planning committee, they wouldn't have known to undertake that tilted balance weighing exercise.
It's got to be both stages, hasn't it? It seems to me, and that
so they've got
if
to
you're
do
going
it
to
and
have
they've
that
got to
special,
report it.
yeah, if you're going to have that special regard, you've got to place great weight. Now, it's not enough for an officer to place great weight if he doesn't tell the committee that they've got to place great weight, because ultimately they're the ones making the decision, aren't they? So it's conversation I have with my son on a regular basis. You can't just get the answer right in a maths exam. You've got to get the working out right in order to get there. So I guess that's it's the same thing. Michael, any sort of Scottish perspective on you don't have the sort of the Barnwell Manor type run of cases which led through to Mordew and this more recent case?
Well, no, no one seemed to at the moment. I mean, from what I've seen, I think it's only really come up in one case that I'm aware of, and in that case they kind of sidestepped the issue, and they didn't need to really consider whether that line of authority was relevant or not. I think in principle it probably is, because the primary legislation is in very similar terms. I think though what's just different again, and it probably reflects again the difference between the process and the approach in the SPP versus the NPPF. There's a lot less detail, a lot less sort of detailed tests in the SPP than there is in the NPPF, and it's the same with listed buildings. It might be that in Scotland the issue is not coming up as much simply because we don't have all these detailed tests. So if you like, the traps that planning authorities sometimes fall into in England aren't maybe quite there in the same way up here. That there's not so many hoops, policy hoops at least, that you necessarily need to go through. And so they don't encounter the problem. That might be down to that.
Yeah. Okay, I think there's one question that's come in for me, which I think I can answer really quickly, so I can just squeeze it in before we run out of time. And that's a question around if Greenbelt or AONB or other footnote 6 policies apply. The question is if they apply and a decision maker concludes that the policies don't lead to a reason for refusal, does that still bar you from accessing the tilted balance? And I think the answer to that is simply no. I think if the Monkhill case is clear, it's not enough for the policy to be relevant, the footnote 6 policy to be relevant. It's got to be relevant, and it's got to lead to a conclusion that there is a reason to refuse because of conflict with that policy, in order to bring paragraph D1 into the mix. So if those policies apply, in that case the AONB policy had applied, but the inspector had considered that there wasn't harm to the AONB from the development, then that wouldn't have justified a reason for refusal, and therefore the applicant could have gone on to look at D2 and applying that tilted balance. So hopefully that answers that question. And that brings us neatly to the hour. So we will maintain our tradition of finishing promptly. So if I can just, Amy, Michael, thank you for joining me today, and thank you to everyone for listening. I hope you enjoyed it, and look forward to seeing you on or at least you seeing me on the March edition in a few weeks' time. But in the meantime, thank you all again, and take care. Bye-bye.